Good morning. We have Mr. Vaca waiting on Mr. Nettleton. Here he comes. Good morning,
Sorry.
gentlemen.
Good morning.
Mr. Vaca, would you like to reserve time, sir?
Yes, Your Honor, I'd like to reserve 5 minutes, please.
Yes, sir.
May it please the court. George Vaca on behalf of the appellant Gerald Williams. We're here today asking the court to reverse the summary judgment that was entered by the trial court with instructions for the court to proceed to trial. Factually, this case is not too terribly complicated. Mr. Williams' home sustained a lightning loss on July 1 of 2009. The case was timely reported to State Farm. Ultimately, State Farm accepted coverage and they made some payments that Mr. Williams believed were significantly less than what he was owed. The claim stretched out for quite a long time, and in August of 2017, 8 years later, State Farm invoked appraisal according to the homeowner's policy it issued to Mr. Williams. Mr. Williams' attorney filed a civil remedies notice in May of 2018. State Farm timely responded to that notice. And after 16 months, the appraisal ultimately resolved with an amount in favor of Mr. Williams, which was significantly more than the amounts that State Farm had previously offered to him. Mr. Williams ultimately filed his 624-155 civil remedies case against State Farm, and State Farm responded by filing a motion to dismiss, or in the alternative, motion for summary judgment. And it put forth the argument relying upon the Supreme Court's decision in Tallet that no cause of action accrued until the 60-day cure period expired. State Farm convinced the trial court that the statutory cure period is tolled until the contractual appraisal was completed, and it did not owe anything. It owed no benefits whatsoever to Mr. Williams until the appraisal had been completed. That same argument has been floated for years. It's the benefit, I guess, of being an old guy and a dinosaur. It's kind of like the old farmer's commercial, right? We know a thing or two because we've seen a thing or two. And so just to give the court some historical perspective, this precise argument that the contract takes precedence or controls the statute was first addressed by the Florida Supreme Court in 1994 in a case called Imhoff versus Nationwide. And the court rejected that argument. I happened to represent the insurance company in that case, and I was successful in convincing 1 out of 7 justices that my position on that the contract took precedence over the statute was correct. If the court were to look at Justice McDonald's dissent in that case, he thought it was unnecessary to respond to the certified question from the first district that brought the case to the Supreme Court. Imhoff and Nationwide agreed in the contract between them to arbitrate any dispute on the amount of damages. Nationwide had a right to rely on this provision. Arbitration was accomplished and the amount awarded was within the coverage. Under these circumstances, the trial judge correctly dismissed Imhoff's claim. Of course, that was directly opposite to the court's holding that the amount of the arbitration award showed that Mr. Imhoff had a valid claim. Didn't matter whether he had a claim in excess of the policy limits or not. There was coverage, and the fact that there was an award in his favor showed that he had a valid claim, and that was all that was necessary to proceed forward with the bad faith case. After Imhoff, this argument about the statute was controlled by the contract was again floated and was again addressed by the Supreme Court in a case called Vest versus Travelers. I know a little bit about this case because I was the attorney representing Travelers, not at the Supreme Court, but at the First District, who had affirmed a decision in favor of Travelers, arguing the same thing, that, hey, wait a minute, how can we be in bad faith if we haven't breached a contract? The Supreme Court in Vest made quite clear, and if you take nothing else away from my oral argument, the one thing I hope you do take away from it is Vest is the poll star case to look at. to resolve the issues in this case. And the court there said, we point out, while not confronting the issue directly, Imhoff, Brookins, which is a fourth DCA decision, and Time Insurance Company versus Berger, all implicitly recognize that there can be a recovery for damages incurred from a violation of section 624, 155, 1B1, which occurred before the determination of liability or the extent of damages on the underlying insurance contract as required by our decision in Blanchard. So what Vest clearly articulates is that there are separate coextensive duties that arise in these situations. There are the contractual duties that State Farm argues trumps the statutory duty, and the statutory duty. And what Vest clearly says is, no, the contractual duty does not trump the statutory duty. They are coexistent duties. And just because you may have complied with one doesn't mean that that preempts the other one, which is the argument that State Farm has made in this case, and they've made it throughout the years as I continue to progress. The argument has been made over and over again. And in this case, they made the same argument, but they put a different shade of lipstick on it to convince the trial court, hey, we're not really arguing this, we're now arguing tolling. So after Vest, this argument again arose in the 4th District in a case called Trafalgar at Greenacres versus Zurich. The issue in that case was, hey, what happens if we go to appraisal? Doesn't the contract requiring that the lost payment provision requiring appraisal, doesn't that preempt the 624 and 155 claim? And there the 4th District said, we reject Zurich's argument that a summary judgment in favor of the underlying breach of contract action precludes Trafalgar's ability to pursue a bad faith claim. A judgment on a breach of contract action is not the only way of obtaining a favorable resolution, referring again back to the State Farm case. As our Supreme Court has recognized, an arbitration award establishing the validity of an insurance claim satisfies the condition precedent required to bring a bad faith action. And then they cite to the Dadeland case. So after Trafalgar, my good friend and colleague, Mr. Nettleton, and I argued about this again in a case called Camerata. He was representing State Farm, I was representing the policyholder. Same basic facts as was in the Trafalgar case. There was a civil remedies notice filed. There was an appraisal that had been invoked. And the question was whether or not the contract, again, took precedence over the statute. And the 4th District agreed with its previous decision in Trafalgar and said, hey, wait a minute, there is a separate independent obligation on the insurance company to evaluate the claim as stated in Vest upon the information that it has at the time the civil remedies notice is received, and to make a good faith offer or attempt to settle and resolve the claim. And if it goes past that point and the appraisal comes back and the appraisal award is anything, it demonstrates that there was a good faith basis. The insurance companies insured had a claim that was meritorious, and now we go forward and we let a jury decide whether or not the insurance company's response was reasonable and in good faith.
What was the name of the last case? I forgot again.
Yes, Your Honor. This is Camerata.
Camerata. Okay, thanks.
State Farm.
Okay, thanks.
Mr. Vaca, State Farm's argument seems to be there was nothing owed when your CRN was filed. So they had no duty to respond to it per the statute. Did you address that?
Yeah, there clearly were benefits owed. There simply wasn't a dispute as to the amount. If there were no benefits owed, there would have been no basis to invoke appraisal. State Farm never denied coverage in this case. They simply disagreed on the amount. And if you disagree on the amount, you can't say that there's none there. And if it's going to be zero, then there has to be a declination of coverage, for which there was not in this case. They accepted the coverage. They made payments. Mr. Williams disputed that he was receiving the appropriate amount of money from State Farm. So I think that argument is disingenuous. There clearly was benefits that were owed. State Farm acknowledged that. And they acknowledged it when they invoked the appraisal that said, hey, we have a dispute as to how much is owed.
Does that dispute matter once you file the CRN alleging bad faith in claims handling? Aren't those two different legal principles?
Yes, absolutely.
The obligation to determine liability and the amount of damages versus the obligation to handle it in good faith.
I think that's what I was trying to say, probably not as artfully as you just did. There are two separate duties. There's the contractual duty we have over here. Hey, we have a covered loss. You say it's worth $500. Insurance company says it's worth $200. I'm not going to accept your $200. Okay, let's go to appraisal, because that's the way that we decided we would do it in the contract. That's how that dispute is going to be resolved. That doesn't mean that the insurance company, who is, according to the case law, Vest, again, go back to Vest, are the people who are specifically trained to know these things. That doesn't mean that they don't have an independent obligation to sit there, evaluate the loss based upon the proof of loss or whatever information they have at the time they receive the civil remedies notice, and to then make a good faith offer of what they believe is the value of the claim at that time. That's what Vest says they're supposed to do. So even if they're ultimately wrong on the appraisal, ultimately right on the appraisal, it doesn't matter. That's what the Imhoff case says, right? Imhoff case was, hey, we have a right to go to appraisal, and we got an appraisal, we got a arbitration. I'm that old, I still remember arbitration. But we went to a arbitration and we got an award that was less than the limits. How could we be in bad faith? Okay, that was the issue in Imhoff. And the Supreme Court said, different issue, different question. The arbitration award simply showed that he had a legitimate claim. And that's all that Blanchard requires. And so that's where we come back to now, right? Mr. Williams had a legitimate claim, and they could say he was owed nothing, but that's not true, because once they invoke appraisal, they admit that there's coverage. Now we're saying, yes, there's coverage for the damages. We don't agree on how much. And what 624-155 requires them to do is to make an assessment, a good faith assessment of how much, and to offer that to him. And I think that's what Landers said, another case I've had with State Farm. It's what this court said in the Fortune case. All right. And so the same argument was made. Again, there's different variations of it, but it's all based on the same central thing. Our contract takes precedence over the statute. And this court rejected that precise argument in Fortune and said, hey, no, there's no tolling. If there was tolling, it would be in the statute. And to the extent that there's tolling, and there's been an amendment in the statute 2019, it doesn't toll this forever until the resolution of the appraisal. It tolls it only for the 60 days after the appraisal was invoked. And if I filed if I filed the civil remedies notice a day before the insurance company invokes appraisal, it doesn't apply at all, is what the court said in Fortune. Most recently, Mr. Nettleton had the ability to make the identical argument that was made by State Farm in this case to the trial court in Zaleski, fourth DCA case that came out of February this year. And in Zaleski, the court specifically rejected this now new version of the same spin of the argument. They've rejected this color of the lipstick and have said, no, this does not toll, the appraisal does not toll the 60-day cure period. There's two separate independent duties. So for all of those reasons, and for all of that case law and all of that precedent, we would ask the court to reverse the summary judgment. Now, in their answer brief, they've also raised the argument about the sufficiency of the CRN. And this comes out of a case which, unfortunately, I also happen to be responsible for, which is a Julian case out of the fourth DCA. A couple of things about this argument. First and foremost, they argue, well, hey, you can apply the Tipsy-Coachman rule and you can evaluate the sufficiency of the CRN and you can affirm the summary judgment because we made this argument in a motion to dismiss that was combined with our motion for summary judgment. And I would simply cite the court to its own decision in the HSBC Bank versus Nelson case, a more recent ruling on the same issue of law that says, hey, no, we can't apply tipsy coachman where the order doesn't make specific findings of fact, which would allow us to do this. The motion to dismiss in this case, based upon the sufficiency of the CRN, was denied. The other case I would cite to the court is a more recent one out of the Fifth DCA, Garrity versus Stewart. It's cited in the brief, but it stands for the same proposition. If the court is inclined at all to go to the merits on the sufficiency of the CRN argument, I would point out to the court a couple of things. One, we were not provided the privilege of oral argument in Julian. The statute that was interpreted by the court there does not have some type of different standard for addressing motions to dismiss. It's not like some other statutes that do. This one does not. So the court is required to, at least as I understand the law, to accept all well-pleaded allegations as true. And if any of those as true would state a cause of action, then a motion to dismiss should be denied. So in this case, it is unquestionable, regardless, and I would say on the merits, that this civil remedies notice is clearly not the same one that was in Julian.
Just want to note you have 4 minutes left. You can use them.
All right, I'll finish this thought, Your Honor. Thank you. The one thing I would say is there is no question that this civil remedies notice and the complaint state a cause of action under 624, 155, 1B1, which is the failure to settle when they could have and should have had the whole argument about had they acted honestly and fairly towards their insured's interest. So my beef with Julian, regardless of however you decide what is sufficiently specific, is that the court threw the baby out with the bathwater, because there were multiple statutory violations alleged, and clearly that case, there had not been a settlement. So the court erred, in my opinion, in throwing out the entire case, as opposed to those allegations of violations of the statute that the court found was not sufficiently specified in the civil remedies notice. So with that, I'll reserve whatever else time I have. Thank you very much.
All right, you have 3.5 minutes, sir.
Thank you, Your Honor.
Mr. Nettleton, good morning, sir.
Good morning, Your Honor. May it please the court, Paul Nettleton of Carlton Fields on behalf of the appellee and defendant below, State Farm Florida Insurance Company. Before I get into the merits of the details of the arguments, I'd just like to summarize our points, and that is, and I think this is important because I think Mr. Vaca and I are arguing two different cases here. Our position is that the summary judgment should be affirmed for two reasons. First, under the undisputed chronology of events here, we submit that the trial court properly held that the 60-day cure period under 624.155 had to be told until the appraisal award was filed with State Farm. And that's because, in the words of Talent, that appraisal award being filed with State Farm was a condition precedent to any payment being owed under the policy. And so therefore, since we paid it within 60 days of the appraisal award being filed with State Farm, we cured. The second reason, as we just heard from Mr. Vaca, is our position is that even though the trial court did not reach it, this court can affirm based on the deficiencies in the CRN that are a condition precedent to this bad faith action under the statute. The deficiencies include the requirement of specificity as to the statutes violated, to the policy language involved. That's the Julian case, as well as the facts and circumstances giving rise to the violation, which is the Lane case we rely on. And Your Honor, before I get into the details of these arguments, I'd just like to respond to Mr. Vaca's comments about this whole line of cases, beginning with Emoff, Trafalgar, Camerata, the Hunt case, which you didn't mention out of this court. All of those cases have nothing to do with what we're here about. All of those cases involved the Blanchard rule of ripeness, and that is a bad faith claim ripe? When does a bad faith claim become right? And Blanchard said it has to be a determination of liability and damages. And the issues in those cases were does that issue of determination of liability, does it have to be liability for breach of contract, or does it have to be liability for coverage under the policy? And those courts all held it was the latter. We did not make that argument in this case. We have not argued that the bad faith claim is unripe because there was no determination of liability or damages.
But
What
you've
we're arguing-
you've argued that it's told, and Fortune, which is our case, which it seems to me we'd have to recede from, and Zaleski expressly hold that a CRN can be filed during appraisal and the insurer's response is not dependent on the determination of damages by way of appraisal. And the language of 624-155 subsection 3 subsection D does not toll the cure period until an appraisal is completed. So what novel argument do you have today?
Well, Your Honor, I would submit that both Fortune and Zaleski are not controlling here. If you look at the opinions in both of those cases, the argument in Fortune that is repeated in the court's opinion is that the insurer argued that by mere invoking of appraisal and proceeding with the appraisal process, that was a cure. There's nothing in the opinion in Fortune that suggests that the appraisal award was a condition precedent, which I'm going to talk about in this case.
But the condition precedent that you're talking about is based on the policy language. So since when does an insurance policy trump statutory language? Show me in 624-155 where there is a tolling based on policy language, particularly
Yes,
appraisal.
Your Honor, we're not asking this court to add any language to the statute.
I think you are.
What we're asking the court to do, Judge Sleet, is to follow the Supreme Court's interpretation of that statute in Talent. And we submit, here's where we diverge, I think, from Mr. Vaca, and that is we submit that the cure period here cannot be divorced from the language of the policy or the definition of contractual amount due as defined by the Supreme Court in Talent. As Judge Battles recognized at the hearing below on this, if plaintiff's argument were right, that you had to make a payment within 60 days of the CRN being filed, even if it's not owed under the policy, which is our point here under the condition precedent, that the CRN essentially nullifies the terms of the contract. And the Supreme Court has been very careful in Talent and Invest in avoiding that particular result. In Talent, what the court said is the policy terms must be applied in addressing this cure. The Supreme Court held that the way you cure is you pay the contractual amount due. And the court defined that as the contractual amount due is the amount owed, and I'm quoting, pursuant to the express terms and conditions of the policy after all of the conditions precedent of the insurance policy in respect to payment are fulfilled. So the court in Talent specifically tied the cure payment to the terms and conditions of the policy and conditions precedent in the policy. And the court
Did Talent extend the 60-day statutory requirement for the insurer to respond?
No, Your Honor, it did
and
not.
And Talent was paid before the 60 days expired.
Absolutely, Your Honor. It's factually a different case.
So you're arguing that the policy language in a State Farm policy trumps statute.
I'm not, Your Honor. I'm saying that the Supreme Court has held that the amount due that you have to pay to cure is defined by the terms and conditions of the policy. So you have to look at the terms and condition of the policy to determine if an amount is due. And if it's not, then how else do you apply the cure and notice and cure provisions without tolling the statute? And let me turn to Vest. Vest was that counsel was saying was the beginning and ending of this case. We certainly have no concern with Vest. Vest also, by the way, dealt with this Blanchard issue, which is not really relevant here. But in Vest, what the court said that, and this is a very important caveat, because it also was very careful to tie it to the contract. It says that the insurer can cure if payment is owed under the policy. The insurer can cure by paying those benefits owed. It then goes on to say what is owed for purposes of the cure pyramid, and I quote again, is governed by whether all conditions precedent for payment contained within the policy have been met. So again, the cure payment is tied to the terms of the policy. In this case,
Where is that in 655, sir? Because subsection 5C, no action shall lie if within 60 days after the insurer receives notice from the department in accordance with the subsection, the damages are paid or the circumstances giving rise to the violation are corrected. It says nothing about your insurance policy except otherwise provided in an insurance policy. It doesn't say that.
it doesn't say that this trumps the insurance provisions either. What the plaintiff's argument here is by filing a CRN, the insured can essentially wipe out the terms and conditions of the policy and require a payment that's not due under the policy within 60 days. And Talent was very careful. Vest, the Supreme Court in both those cases, was very careful to avoid that very result by saying the cure amount is the amount due under the policy pursuant to the terms and conditions after all conditions preceding have been fulfilled. And we have condition 8 in this particular policy, which we've highlighted, we've quoted. It's a lost payment condition, and it clearly says, and I'll agree, appraisal is not always a condition preceding. In some cases, it doesn't even come into play. But where the parties, and here it was both parties demanded appraisal, both State Farm and then 4 months later the insured, when appraisal is invoked because there's a disagreement as to the amount of the loss, that the amount that no payment is due until 60 days after that appraisal award is filed with State Farm. That is a condition preceding to payment as defined in the Talent case. It's undisputed, of course, that there was no appraisal award within 60 days. It was 7 months later. And so therefore, the only way to give effect to the notice and cure and give the State Farm any opportunity to cure here is to toll that 60-day period. Now, again, Fortune did not address the terms of the policy or any conditions preceding. In fact, it appeared to specifically find that amount was due at the time that the CRN was filed in that case. It quotes Vest repeatedly in the course of the case, which continually says, if payment is due, then the way you cure is pay. If payment is not due, then what do you do? The court was always careful to caveat its decisions of paying within 60 days if payment is due under the terms and conditions of the policy. So we submit Fortune is not controlling because it doesn't discuss whether there was a condition preceding requiring the appraisal award in that case like there is in this case. In Zaleski, we've acknowledged we made the same argument in that case. However, we believe the 4th District recast our argument to follow Fortune. and recast it in the very terms of Fortune that said that we argued that mere invoking of appraisal and paying the appraisal award is enough. Now, admittedly, in both Fortune and in Zaleski, the court indicated that appraisal is not a condition preceding. What it says is not a condition preceding to making a fair evaluation and making a fair payment on the claim. Of course, State Farm believes it did that, but nevertheless, that's not really the issue here. The condition preceding question is it a condition preceding to payment under the policy? And we submit clearly you cannot read this policy term, the lost payment condition, without finding it is a condition preceding. And so we submit there was nothing owed under the policy at the time the CRN was filed, and therefore there was no ability for State Farm to cure within 60 days of that date. And if you're going to give the insurer an opportunity to cure, which in Talent, the Supreme Court said has to occur or there's no claim under the statute, the only option is to toll that period.
Well, even assuming you're right, the fact that State Farm invoked appraisal, you acknowledge something was owed.
We did not, Your Honor, because the appraisal.
Why invoke appraisal? Why invoke appraisal? Go to trial.
Your Honor, the reason to invoke appraisal is where there's a disagreement as to the amount. State Farm believed.
Well, which means you believe there's amount due, but you just disagree on it.
No, what we disagreed on is we believe we paid the amount that was due. The appraisal process is there because the insured disagreed with that. The appraisal process could have come back under or at the amount that was already been paid. It doesn't mean necessarily that there is more due. it's not until the end of that process you find out whether more is due. And at the time the CRN was filed, of course, nobody knew what that process was going to come out to. So there was no way to even make a payment to cure. And Your Honor, if I'd like to move to the second one real quick, because Mr. Vaca indicated that this court should not even consider it under the Tipsy-Coachman doctrine because of factual findings that need to be made. Well, there's no factual findings involved here. Review of a CRN for sufficiency is a de novo. It's based on the content of the CRN. That's undisputed. It's attached to the complaint. Julian so held, and Julian said it's a de novo review of that particular document.
Yeah, but the problem I have with Julian is it's devoid of any other facts about the filings. It's devoid of any recitation of the facts and circumstances that Julian submitted. In this particular case, you have 4.5 pages of a chronological facts and circumstances. He said, she said, they didn't pay it enough, pool damages, flooring, home entertainment, AC rugs, State Farm admitting that they didn't have the expertise to assess damages to home entertainment centers. And then they name certain adjusters who acted in bad faith. It goes on and on and on. And Zaleski, the same court, 4th DCA, said that Zaleski's CRN was sufficient because it stated specific statutory provisions, gave a detailed recitation of the facts surrounding the violation, alleged that State Farm performed a cursory inspection of the property, failed to retain experts, make necessary repair, and gave a lowball offer. Same thing that Mr. Williams did.
Your Honor, first of all, there's two different issues involved.
You got a minute.
Yes, Your Honor.
Actually, you got 5 minutes. I'm sorry, you got 5 minutes.
Your Honor, and Julian addressed two aspects of the civil remedy notice. It did not address the facts and circumstances portion of it. That's the Lane case, which is our second argument. But under Julian, the court merely looked at the civil remedy notice specificity as to the statutes, recognized that it asserted essentially every actionable statute, including some that weren't in Florida Administrative Code. So that did not comply with specificity. It looked at the language of the policy relevant to the alleged violations, and it said it essentially adopted the entire policy. Those were the lack of specificity provisions that the court looked at in Julian. It didn't look at the facts and circumstances in that case, and it held that that alone was sufficient to dismiss the action because it did not comply with the statute. We had the exact same situation here, Your Honor. CRN here, if you look at it, looks very similar. Take out the facts and circumstances. I'm talking now about the statutes allegedly violated.
Yeah, but the facts and circumstances are required by statute. So you're telling me that if the facts and circumstances are not detailed enough and specific enough, if they are detailed and specific enough to put the insurer on notice as to what policy provisions they violated and what statutory obligations they violated, it's still legally insufficient.
Perhaps not, Your Honor, but the facts and circumstances don't go into the policy provisions. They don't go into the statutes. They do paraphrase the statutes again. But again, that is not sufficient under Julian. Under the other provisions of the thing, the CRN here, as I said, looks very similar to the one in Julian because it's prepared by the same firm. They identified all kinds of statutes, including ones that weren't actionable, as well as Florida administrative codes that not actionable. And it identified essentially every provision in the policy, the same as Julian. So that alone we submit under Julian, if the court were to follow Julian, required dismissal with prejudice or summary judgment here.
But the statute only requires you to indicate all statutory provisions. You don't have to say why. You just indicate it, which he did. The problem with Julian, the problem that Judge Koontz had was that he listed each and every policy provision known to man from A to Z and every subsection.
And that's the same here, Your Honor.
Well, I'm not looking at every definition, subsection. I'm looking at dwelling, personal property, loss of use, declarations, and everything else. But as I look at his detailed facts and circumstances, he talks about issues concerning loss of use, personal property, dwelling, flooring, roofing, AC, everything else.
Your Honor, again, it identifies every provision in the policy, coverage A, coverage B, coverage C, but without citing the policy language. Remember, the statute requires the language of the policy that's implicated in the violation to be recited, which never occurs in the CRN anywhere. But going to the facts and circumstances, Your Honor, in Lane, the court said they're too vague to allow the insurer to know what to do to cure, that doesn't comply with the statute. Now, admittedly, Your Honor, the allegations here are lengthy, and I would submit prolix, but prolixity is no substitute for specificity. These allegations, for the most part, simply paraphrase the statutes. They're boilerplate to other CRNs that are always filed against other insurers, regardless of the claims. And the allegations of the statutes, Your Honor, are all kinds of divergent things, which the facts and circumstances, other than paraphrasing the statute, the facts and circumstances allegations do not support. For instance, misrepresentations are a couple of the statutory violations. There's no indication in the facts and circumstances of what misrepresentations were made by State Farm. It says one of the statutes they cite is failing to respond to communications. There's no reference in the facts and circumstances as to what particular communications were not responded to. Failing to explain the basis for the claims decisions and the payments. Those are a couple other statutory provisions. Nothing in the facts and circumstances alleged which would suggest there was a failure to explain the decisions and the payments that were made along the way.
So for example, to say that adjusters would schedule meetings and then not show, that's not enough for you?
No, Your Honor.
Adjusters would yell at Mr. Williams and use racial slurs or racial implications.
Again,
he was personally disrespected. They admitted that they didn't have the expertise to assess the value of a home entertainment system. That's not enough?
Your Honor, those do not tie into the particular statutory violations that are claiming here. And I'd make it clear, as the court I'm sure is aware, we deny many of those allegations, but we accept them for purposes of our motion at this point. The point is that the CRN was not sufficiently specific to advise State Farm how it could cure these particular violations. And in fact, what it says for the most of the supposed cure demands is pay the amount that's owed. Well, again, nothing was owed pursuant to the condition preceding in the policy because the appraisal award had not been filed yet. And certainly no one knew what amount was going to be owed if the appraisal award came out above what State Farm had already paid. In addition, their cure demand also required us to do things that the Supreme Court has expressly held are not required to cure, such as pay attorney's fees and pay expert fees. Those are extra contractual damages that the Supreme Court in Talent said do not have to be paid. So we submit for all of those reasons, Your Honor, that the CRN was deficient. We submit that under Talent, under Best, and its tying of the cure payment to the terms and conditions of the policy, that we effectively cured here, and that the trial court was entirely correct in granting the motion for summary judgment, and we'd ask that the court affirm.
Okay, thank you, sir. Mr. Vaca, you have 3.5.
Thank you, Your Honor. So let me go to the first part of the argument first. And I appreciate Mr. Nettleman's reliance upon Talent, but Talent has no application here because the major difference is the civil remedies notice in Talent was filed after the claim had been paid, not prior to the payment being made. So for our case, it simply has no application. Second, again, I asked the court to go back to Vest. And in Vest, there's, please forgive me, but it just seems so pertinent that I read this quote. There is no statutory requirement which prevents the insured from sending the statutory notice before there is a determination of liability or damages, nor is the insurer's appropriate response to that notice dependent on such a determination. An insurer, however, must evaluate a claim based upon proof of loss required by the policy and its expertise in advance of a determination by a court or arbitration. That's the part that State Farm refuses to accept. It has been the law of this state for almost 30 years, and it is the part that makes their argument flawed, as was critically pointed out by Zaleski, in which this precise argument was made. And the court there said, hey, there's no such language in the statute providing for this tolling. Go back and read Vest. That's what this is all about. As it pertains to the CRN, Your Honor, Judge Sleet, you hit it right on the head. If these allegations concerning racial slurs and the way this insured was treated is boilerplate for State Farm, that speaks volumes about their claims handling practice, and they should not be bragging about it. They should be ashamed of it. Most respectfully, the trial court in this case got this one drastically wrong. This argument is simply the same one dressed up in a different way and being pitched at you from a different point of view. There are two independent coexistent duties, and this complaint clearly stated that State Farm breached its independent statutory duties. The one other thing I did find that was, and just as a side note, it was interesting to me that State Farm cited to its response to the civil remedies notice for the factual predicate for its summary judgment argument, which it just seemed to me kind of weird that you would cite to your lawyer's response to something as the factual predicate and then represent those as facts. But in any event, I believe that Judge Battles got this one terribly wrong. And that based upon this court's decision in Fortune, based upon the Fourth District's decision in Zaleski, based upon the Supreme Court's decision in Vest, this court should reverse the summary judgment with directions on remand to conduct a trial in this case, resolve the factual issues of whether or not State Farm committed bad faith in handling of this claim.
Okay, thank you very much. Well argued. We appreciate it. If you could please now leave. You can remain and watch. I doubt you will, but have a good day.